Nyali Banjalangni Rakol Jugun Nyali Gani Garama Mala Jugun.
So I'd like to just acknowledge the traditional custodians of this land on which Mullumbimby stands, the Bunjalang people, and to offer on behalf of everyone our deep respect and acknowledgement of the way they have known how to live on this land without harming it and without damaging it in any way. And on that note, I would like to welcome Stephen Blanks, who is giving a very exciting talk tonight. I think it's called I Protest, and I'm sure a lot of us here in Mullumbimby are very well aware of why we should actively oppose the new New South Wales anti-protest laws. So Stephen is president of the New South Wales Council of Civil Liberties. He is also a solicitor in Rozelle, Sydney. So let's have a warm Mullumbimby welcome for Stephen Blanks.
Now, I am going to talk about protest tonight. I think I quite like I Protest. It's a catchy and shorter title. I'm trying to make it short. The longer title I had was Why We Need to Protest Against the Laws Against Protest, which is a nice circular problem, and I think it's a particular problem that arises in New South Wales now, because we have had in March through the New South Wales Parliament the most extraordinary set of laws aimed specifically at protest, and the most draconian anti-protest laws that this state, I think, has ever seen. Now, protest, of course, is one of the most fundamental, legitimate means by which you can exercise your right of free speech. And the right to free speech is a right which has been found to exist and be protected by the Australian Constitution in the most curious way, because it's not mentioned in the Australian Constitution once. It's just in the vibes. But that's enough. And we had in New South Wales not a bad regime, I think, overall, where if you gave the police notice that you were going to have a public assembly, then you were allowed to hold your assembly, you were allowed to cause obstruction, that is block the road and stop the traffic and cause inconvenience to people, and the police couldn't prosecute you for unlawful assembly or for causing obstruction. You just had to give them 7 days notice. Now, there was a provision that the police commissioner could apply to the Supreme Court for an order to prohibit the protest, and there's been a few controversial cases where he did that. The first one goes back 30 years or so. There are some people around, perhaps not up here, but there are some people around who still have that as living memory, including a Supreme Court judge who was one of the organisers of the protest, which was the subject of the case when she was president of the Council for Civil Liberties in the early 80s. And that was a protest that she organised on Anzac Day down the main Anzac march route that the veterans were going to walk down, and she was organising a group of women to go ahead of the Anzac marches to protest against rape in war. And that is such an un-Australian idea of protest that the police commissioner went to the Supreme Court and got an order prohibiting that. After that case, there were almost no examples of protest cases in the court until 2003, when a well-known activist in the refugee field decided that he would organise a protest outside Philip Ruddock's private residence, which is in Britannia Avenue, suitably, Pennant Hills in Sydney. Or at least it was at that time. I don't know where it is now. And it raised a whole lot of interesting questions. That is it legitimate to protest against a politician whom you abhor, which is about half of them, not at their official place of work, but outside their private residence? And the particular problem the police had is that that road was the only road into a whole lot of local sporting facilities, and the protest was scheduled for a Saturday morning, and there were going to be a whole lot of very unhappy children and sporting mothers as a result of that protest. But we went to the Supreme Court, and the court upheld the right to protest and said, no, it's a legitimate aspect to the right to protest, the right to free speech, that you are allowed to protest outside the private residence of a politician. So that's not a bad precedent. More recently, there have been some cases which have gone the other way. Somebody tried to organise a protest on Oxford Street in Sydney during peak hour on a weekday afternoon. You probably don't have peak hour up here in Mullumbimby. Peak hour at Oxford Street is a particularly unpleasant phenomenon, and the idea was to have a protest outside the Israeli Film Festival, which was being held. One of the cinemas was right on Oxford Street in Paddington, and the police thought it was just too inconvenient to the general public, and they couldn't assure safety if part of Oxford Street was closed off for such a protest. And I must say, to my surprise, the Supreme Court agreed with the police and said, no, you can't block important city streets like that. That's probably where the contest of causing obstruction in the traditional sense has been. The police did allow a protest earlier this year down Elizabeth Street in the city, which again was designed to cause maximum inconvenience. The police ummed and ahed about whether they would go to the court, but decided not to. So that was the state of play until we get to March this year, when without any public consultation, the New South Wales government decided to enact 4 separate pieces of legislation, each of which is highly draconian in its own way, or to use the language of the New South Wales government, these are tough new powers. And why the phrase tough new powers is politically attractive is a complete mystery to me. I think, and perhaps we're coming to the end of the days where the phrase tough powers is a politically attractive phrase. Perhaps the shock of what we saw in the Northern Territory this week by a government which promotes itself as tough on crime and tough on law and order, maybe the gloss is coming off that word tough. In truth, it just means draconian. The legislation that went through in March has a number of very disturbing aspects to it. One of them, and all of them, are designed to enable police and the courts to take action against people who are not accused of having committed any crime. It is a substantial shift away from the idea that we live in a free society and you're free unless you've committed a crime and have been convicted for it. And now the legal regime has shifted in a very significant way, so that the police and the courts have got power to deal with people who are not convicted of a crime, but who might only be suspected of being involved, but no one can prove it, or indeed where it's assessed that people intend to do something in the future, even if they haven't actually done anything at all. And one of the aspects of the anti-protest laws which went through is criminalisation of intention to interfere with business activities. And I know there are a few lock the gate people here tonight. It seems to me that those laws are aimed directly at you because you make your objectives from your protest very clear, and so can be your intention of what you do is able to be inferred, and it's an attempt to criminalise the intention. One of the great things about these new laws, you see, there's always some silver lining. Seems to me that there's going to be a lot of work for some really creative lawyers in challenging laws of this kind. And the challenges, I think, to laws which criminalise intention to do something potentially could go all the way up to the High Court. So that's one of the areas which in March the government... Look, I should say I'm happy to sort of talk, and I've got 1,000 topics I can talk on, but I'm also happy to take questions. So when people get bored with what I'm saying, feel free to sort of take me down a different line or ask a question. Ask me to speak about a particular issue that's bothering you, or not bothering you, interesting you.
We do that.
Does the legislation cover the provision of people locking onto each other, making a large immovable sort of conga line-like mass? Where does the legislation stand on that?
You know, that is the value of a gathering like this here tonight. The creativity of people up here is fantastic. No, and I don't think they thought of that one. Because the locking on, the specific locking on provisions in the Act relate to locking on to property. There was after the laws were passed, the world's biggest lock-on, which took place, it was advertised as the world's biggest lock-on. I don't know if that was mere puffery or whether it was statistically correct, but it was to take place in Macquarie Street outside New South Wales Parliament House. And I understand that the lock-on took place and no one was arrested. 100 people locked on. Let's see that it's great being up here. There are so many people who know more than I do. There are disturbing sections in the new law which allow police to give directions to people who are causing obstruction. So, notwithstanding that. One piece of legislation, the Summary Offences Act, for a public assembly for which 7 days notice has been given, you've got immunity from prosecution against obstruction. The new legislation allows police to give effectively move-on orders if obstruction is being caused, and then if people don't move on, they're liable to arrest and quite serious penalties. So. As creative as that lock-on strategy, locking onto other people, might be, I'm not going to give a legal advice right now that it'll actually work. I suppose I'm just going to broaden the discussion beyond protest a little bit, because I've actually had a really great day today. I've come up from Sydney. I had lunch with a family up in the Gold Coast who I acted for, a family of refugees who came to Australia by boat from Sri Lanka in 2009. And the father and came on one boat, and the mother and children came on a separate boat, and the mother and the children were on a boat that sank, and they were rescued at sea by the Oceanic Viking. I don't know if that rings any bells for anyone. It had a lot of media attention at the time, because the Oceanic Viking was an Australian customs vessel. The Labor government of the day, Kevin Rudd's government, directed it to return the people to Indonesia, where when it arrived in Indonesia, they refused to get off the boat, and Indonesia refused to take them involuntarily. And there was a standoff for about a month until Australia agreed to take them. Well, this particular family ultimately got reunited on Christmas Island, but for reasons which are largely still unknown, ASIO gave them an adverse security assessment, which resulted in the Prime Minister saying, well, okay, we've taken them to Christmas Island, but they will never set foot on the mainland of Australia. That was Kevin Rudd. They will never set foot on the mainland of Australia. Well, things happened, and very soon the wife became pregnant, and there's a no births policy on Christmas Island. And so under armed guard, they were brought to Sydney for the birth on the basis that they would be sent back to Christmas Island as soon as they were well enough to return. They never seemed to be quite well enough to be returned, and they were in the residential housing section in Villawood under 24-hour guard. They actually had guards in their residence 24/7, following them from room to room, until the Daily Telegraph ran a story saying that these guards were costing the government $1 million a year. Within a week they were gone. It took us 4 years to get them out of detention. They were released the day before their case was due to be heard in the High Court. And to this day, there is no explanation from ASIO. I've got some questions over there. I'll come back in a second when I finish the story. There's no explanation from ASIO to this day as to why ASIO all of a sudden decided on the eve of the court case that they were no longer a threat to the Australian community, and they've now been happily living on the Gold Coast for a couple of years, and the kids are all at school and doing well, and it was a real pleasure today. I had a really pleasant day with them. Now, a question over there.
When you talked about the Anzac protest, you used the expression that it would be un-Australian for people to protest about rape in war ahead of all the organised soldiers marching. Did the Supreme Court make any comment on the definition of un-Australian, which seems to me to be something that politicians throw around and think is going to be a vote catcher? And do you, given that Australia's culture of maverick and free speech and stand up for what you believe in, would you like to make a comment on un-Australian?
Well, great question. No, the Supreme Court didn't actually use the expression un-Australian. That's my interpretation of the case. And I mean, I think everybody can have their own views on what Anzac Day, the celebration or commemoration of Anzac Day has become, and how it will talk about some issues of war and others remain absolutely taboo. And whether the phrase un-Australian is apt, it can mean so many things to different people. It kind of is Australian that we'll sweep some things under the carpet and treat them as taboo subjects and not talk about them. That's probably part of the Australian ethos. It'd be interesting, I think, given the glorification of war, given the centenary anniversary of the First World War, and now all of the attention on the battles of the Western Front and the appalling carnage that occurred there, and still there are taboos about how that can be discussed. And there are things that are not allowed to be said about it, and views that were expressed at the time by the people in the midst of it are views that are not allowed to be expressed, to the extent where you might remember last year a journalist in his private capacity, a journalist employed by the SBS, tweeted on Anzac Day some tweet, I can't remember precisely what he said, but some tweet critical of the way in which Anzac Day is marked, and the consequence was his sacking at the government's insistence. Now, that is an indictment of free speech in this country. I think that incident.
If I can refer back to the topic tonight, I'm interested to know what the status of the legislation is. Is it in draft form, or has it been put to the House?
The status of the legislation is a really good question, because there is there is some uncertainty. It passed Parliament, it got the royal assent by the Governor, and it hasn't been proclaimed to commence. So it's sitting on the statute books, unproclaimed. Now, there is a real political opportunity here for people like you to deliver the message to the government that these laws are unacceptable and should never be proclaimed and should just be allowed to lapse.
It's extraordinary. It's extraordinary that there's been no media. It's extraordinary that there's been no media coverage.
Yeah, the comment was it's extraordinary there's been no media coverage of the fact these laws haven't come into operation. There's been some media coverage when they were enacted. Of course, the main discussion when they were enacted was about terrorism and the need for, whenever there's a terrorist incident anywhere in the world, Australia needs to respond by passing more laws. And now, you ask about what's Australian and un-Australian. The Australian response to any threat seems to be to pass laws. We have more laws dealing with counter-terrorism than any other Western country in the world. Yes?
So would you test the status of the new law by locking on yourself?
Well, would I test the status of the new law by locking on myself? I think somewhere in the introduction it was mentioned that I'm a lawyer, and I have my professional interests and the interests of my clients at heart. I'm very happy for people to take their own views about whether they're prepared to break the law and test the system, but my role in the system is a little bit different. And as a lawyer, particularly since we have some judicial presence here tonight, I'm not going to express an intention to break the law.
I would like to know if someone can find out the cost of the guards to stand alongside that poor Iranian girl who was featured on Australian Story. and her horrible story was overshadowed by the hideousness in the Northern Territory. But it would be good to find out what that's costing, because if ever there was something that's senseless and smacks of smug, blind, stupid bureaucracy, it's Peter Dutton not interfering in her case. And I would like to see someone like Peter Dutton go through what she's gone through and get her. Why do we have to have her in detention? Where is she supposed to go? She's married to an Australian. Why can't she stay? What can we do?
I look at all good points. I think the extraordinary thing about this issue is that one of the ways into effective action on it is to focus on the cost. That's the, you know, if you get the message in a format that the Daily Telegraph can get upset about, as much as we might have other views about the Daily Telegraph, but one thing they will run occasionally is stories on waste. And the way to get the information, I think, is either through FOI or through questions asked in Parliament. I encourage people to press their members of Parliament to ask these questions, to tease out the information that will actually get this turned around. The cost, the irrational costs that the government incurs, not just that individual case, but so many cases. The number of people who are in detention who are married to Australian citizens is extraordinary. It's a growing number. It arises mainly because of, well, at least the cases I'm aware of, because of ASIO giving one party, the foreigner in the marriage, an adverse security assessment so that his visa is cancelled. Of course, if an Australian citizen gets an adverse security assessment from ASIO, then the Australian citizen remains at large. Nothing happens to them. They don't get locked up. They have a right to a set of reasons. They have a right to review in the Administrative Appeals Tribunal. Foreigners, even foreigners married to Australian citizens, even foreigners married to Australian citizens with children who are Australian citizens, don't have those rights, and they are in detention. And I'm acting in some cases which are just disturbing and completely unnecessary.
If, for example, another Bentley blockade were to happen, what would be the procedure, basically?
Well, the method of proclamation is publication of a notice in the Government Gazette. So it is the easiest thing for the government to do at any time, without notice to anyone, without consultation, and perhaps if they take the view that an unacceptable protest is being planned, then they might be tempted to proclaim them. It's a fluid situation. These laws, from my point of view as President of the Council for Civil Liberties, I've done more media on this set of laws that went through in March in New South Wales than on a whole lot of other subjects. And it reflects concern across the whole community. And it's not just media in the places that we get our information from, it's on the commercial side as well. There is, I sense, a community backlash against the government for pushing through these draconian powers. Part of the reason I think that they've been able to do it is that there is a fundamental dysfunction within the New South Wales government in the way that it's organised, with the police minister being more senior than the Attorney General, who is responsible supposedly for justice. And the Attorney General in this New South Wales government is a junior minister, and she reports to the Police Minister, and that is unprecedented in any Western democracy, and it's frankly unacceptable.
Could you give us a feeling for how these laws, these anti-protest, anti-democracy laws have gone down in the legal fraternity, from your feel of it?
Yeah, no, look, well, that's actually a really straightforward question, because the legal fraternity, through its professional bodies, is utterly and absolutely and strongly opposed to these laws. One of the systemic failures in the way these laws, I mentioned the problem that the Police Minister is senior to the Attorney General, who's responsible for the justice system. The other failures in our legal system is we do not have due process in New South Wales Parliament, unlike Victoria and the ACT, where laws have to be assessed for their compliance with human rights standards before they go into Parliament, and parliamentarians get a report on whether they're consistent with human rights standards. These laws that were passed would fail that test, and everybody would know. The other thing, that the government did not consult with the legal profession about these laws, and the legal profession has got a legitimate role in ensuring that the rule of law is observed. The rule of law, now I'll come to civil disobedience in a minute, which is something I've been thinking about in preparation for tonight, because I figured you'd like to know a bit about civil disobedience and what I think about it. But first of all, I'll talk about the rule of law. The rule of law is nothing more than having a rules-based system, so you know whether or not what you do is lawful or unlawful. It is unsatisfactory to give power to the police to make up their minds whether they like what you're doing or not, and can take action against you based on their whims. There needs to be rules, and these laws are fundamentally inconsistent with a rule-based system. One of the powers that they give is for police to themselves make so-called public safety orders, and it is left to the police on the ground. They can make a public safety order that doesn't have to be in writing. It can be only partially communicated, and then the person to whom they've made the order, or the group of people, can be criminalised for disobeying it. It's creating a system where there's one law for some people and a different law for other people, which is another fundamental problem with it. These are the sorts of things that the legal profession has legitimate, should have legitimate input on, and the legal profession has pointed out very strongly that these laws fail those fundamental tests. Now look, you raised the question of civil disobedience, and I may as well address it because I figure that's probably a subject that a lot of you are interested in. When is it okay to break the law? And now, of course, I can't stand up here and say, you should go and break the law.
Go for it.
But I did say that on radio the other day, in response to Monday night was such a huge night for interesting stories. The Northern Territory embarrassment, the refugee married to an Australian citizen, and the other one that emerged on Monday night was a woman whose father had dementia, was in a nursing home, and she was concerned that he was being assaulted by the nursing home staff, or by some of the staff, and in order to prove or confirm her concerns, she hid a camera in his room. And on the camera, she was able to record quite serious abuse. And I was asked, well, you know, isn't putting a camera in that secretly in that situation, isn't that illegal? You know, aren't we opposed to surveillance? You know, we want a society where we're not under constant surveillance all of the time. And my answer was, well, look, sometimes doing the wrong thing can be justified by a greater good. It is sometimes right for whistleblowers to blow the whistle, and there needs to be proper legal protection for people who expose greater wrongs, even if the way they do it is illegal. So, for example, the live baiting of greyhounds exposed through footage probably obtained, vision obtained illegally. The slaughter of cattle in Indonesia, which led to the temporary ban on live exports. Again, illegally obtained. Would anybody seriously argue that that kind of civil disobedience is not justified? Well, only an extremist few, I think. So, you know, civil disobedience has got a place in our society. It's difficult to define exactly where the boundaries of it are. You know, is coal seam gas mining one of those activities which justifies civil disobedience? Well, everybody in a free society is able to make their own decisions. If you get arrested, then I suggest you get good lawyers and hope you find a loophole in the prosecution.
Thanks, Stephen. Look, I just, in conjunction with these laws against protest, there have been, well, I think even more draconian laws about control orders that essentially establish the police as an independent judiciary. Would you care to comment about the control order legislation?
Thank you for raising that, because the New South Wales control order regime, and they're not called control orders, they're called serious crime prevention orders, and that is an absolute euphemism, because they're not going to be used against what you and I think of as serious criminals. They're going to be used in order to control particular groups that are unfashionable. It's an extraordinary move, these laws in New South Wales. The control orders for terrorism offences, or for terrorism suspects at the Commonwealth level are bad enough. In fact, and from a civil liberties point of view, they're unacceptable. And now, in New South Wales, that concept has been adopted. The court is simply made a tool of the police in giving these orders. The court is not going to be provided with any proper evidence to justify the making of the order. All the police need to establish is that the police, they've got some serious concern. There's no real ability to test it, but most fundamentally, in our society, in a free society, if you don't commit a crime, then your fundamental human rights, rights of movement, association, free speech, should not be curtailed. And what these laws permit is curtailment of those fundamental human rights without any due process. Why is the legal profession ignored? Because I think the community is not completely alarmed by these laws.
But why are the legal profession? Because of Murdoch. Obvious.
Hi.
Yeah.
Hi. So Bob Brown is attempting at the moment to launch a High Court case against the workplace anti-protest legislation that was passed in Tasmania. What do you think is going to be the impact on the kind of legislation that's on hold in New South Wales, or that has been passed in Victoria or somewhere like that?
Yes, that's a very good question. For those of you, you probably all know the situation. Bob Brown, the Tasmania passed laws similar to what New South Wales Parliament has passed, which prohibit any kind of protest that interferes with logging or commercial activities. And Bob Brown managed to get himself arrested and charged under those laws, and promptly commenced a case in the High Court challenging the validity of the laws. The Tasmanian police response to the High Court case was to drop the charges. So the question remains whether the High Court case now is merely hypothetical, or whether the High Court is going to allow it to proceed. And look, I'm not quite sure of the status, but the significance of it is that if you have high profile and good PR, you can intimidate the government not to enforce the laws the way they're written. And there is another obvious flaw with these laws, that they're not laws designed or intended to be fairly and uniformly enforced. They're laws designed to give police selective powers against vulnerable people who don't have the ability to fight back.
It's a badly written law.
Hello.
Yeah. Yep.
Oh, you can hear me. Hi. There's the anti-protest laws. There were the anti-land clearing laws, for which there were submissions open in late June, closed in late June. I don't think there were submissions possible for the anti-protest laws. Is that true? I didn't see any.
No, that's right. I mean, the anti-protest laws went through New South Wales Parliament without any public consultation. No public consultation, so no opportunity for submissions from community organisations, and no private consultation either. No consultation with the legal professional bodies and other organisations who are often consulted when these kinds of laws are being considered. And no committee review within the New South Wales Parliament. The best strategy for persuading the government not to proceed with these laws is going to be a multi-pronged strategy, and you'll never know which issue concerns them the most if they don't proceed. But I think the more different kinds of issues that can be raised, from those of a legal nature, those of a free speech nature, those of coal seam gas, environmental protest, and economic arguments, and government cost arguments. I think all of those go into the mix, and the more that there are, the stronger the case.
But can we just sort of like write to them and say, hey, this is going to cost too much to...
I think the community has to organise. Merely writing to the government, I'd never find it particularly effective. It's got to be organisation.
Australia is politically so beholden to the US government and the world order that's forming. Do you really think that they're going to allow us to get out of this sort of enforcing these sort of draconian laws that are being brought in the whole of the EU and America, if they haven't been brought in already. We're really following along in a trend that's been set globally already. Can you please comment on that?
Well, yes. One of the interesting aspects of what we do is we host a lot of interns from Europe and America with the Council for Civil Liberties, and the French ones have been explaining to me that, you know, since the terrorist attacks in France months ago, there's been a state of emergency in France. Now, under the state of emergency, all protest is banned. What has been happening in France is that in every city and every town and every village, every night, there is a protest.
Except for the holidays.
Perhaps except for the holidays, and of course in France there are a few. But I think the lesson for that, and it's sort of integral to the what I'm talking about tonight, the more draconian the laws against protest, the more reason there is to protest for the right to protest. And the classic Australian example, of course, is Queensland, when Bjelke-Petersen banned street protests in Queensland, and what was the result of that? Street protests for the right to have street protests. And the logic of that kind of protest is irrefutable. You've got to be able to have a variety of avenues for expressing whatever view you want to express, and your expression doesn't have to be confined to social media or any other form of media. It can have a physical expression, and physical protests have, particularly when they have symbolic elements to them, can be extraordinarily effective. The world's biggest lock-on was an example of a protest designed to show how stupid the law against lock-ons is going to be. So, yes.
Since the laws haven't been passed, haven't been proclaimed, although they have been passed, can they be rescinded? And what is the most constructive thing that we can do to ensure they aren't proclaimed?
They can be rescinded. One issue I'm just not sure about is whether they lapse naturally after a period of time. If they're not proclaimed within a period of time, they possibly just naturally lapse, and that's something I've been meaning to research and I haven't managed to do so yet. It's a big thing, I think, politically, to persuade a government to repeal laws that it's passed. It would be a major backdown, and so you've got to think strategically about how do you get the government to reposition itself, to get itself out of the hole that it's dug itself into. And that's the reason I mention the structural issue of the police minister being senior to the Attorney General, because it seems to me that one way, one very orthodox set of representations that can be made to this government is that they should remedy that situation and restore justice as the primary interest of government, and make the police a servant of the justice system, not the owner of it.
Yes, lawyers should say that.
I just did.
To the government.
Well, would you log on for that?
No.
We would. We have.
Do you think that the fact that the law was brought through without consultation could be the grounds for challenging the basis of the law? Because for such an important piece of civil liberty to be taken away without community consultation, do you think there's a technical possibility that that could be the grounds for challenging?
Yeah, it's interesting. I don't think so. That's not the way. It's not the way legal challenges work. The parliamentary process itself is not impugnable in court. So one has to argue that the laws are inconsistent with the constitutional right of free speech, or more likely, but perhaps not as a whole, but particular instances of police application of them are. When the police charge somebody with intention to interfere with a business, merely, that is a thought crime. It's nothing more than a thought crime. I think there's potential for challenging that. When the police charge somebody in a protest over here because another person in the protest over there has a lock-on implement, then I think there is room for a legal challenge. So I think the challenges are going to come from specific instances of the way in which the laws are implemented, rather than a global challenge to the validity altogether. But look, the Bob Brown case in the High Court, might get up, and it might be the death knell for these cases. So, if anybody has ideas for creative legal challenges, then by all means go for them.
I like to know my enemy, so I do read the Murdoch press. And there's a very interesting article in this morning's Australian which discusses in the Turkish situation and how the recent coup attempt is described as Erdogan's Reichstag moment, and which is the moment that gives him the opportunity to crack down and to close the schools, the people, arrest everybody who disagrees with him. So, do you have a view on what was Mike Baird's Reichstag moment?
Well, I recommend that article to everybody in the audience tonight. I thought that was a very perceptive analogy and a scarily true one. I think what's going on in Turkey at the moment is serious danger to not just the Turkish population, but the rest of the world. Has Mike Baird had a Reichstag moment? Is greyhound racing it? This audience is... I don't know, what is the view of this audience on greyhound racing? The view from the city is that all country people are for greyhound racing and think it's fabulous. But, right, okay, well that's good. So you could do quite well in Balmain, where I live. Fit in quite well. What I've heard about the greyhound laws, by the way, is that it's a redevelopment. He said that it's not for private redevelopment of Wentworth Park, which is the central green space. You can take him at his word about that. Apparently what the intention is, they're going to move Balmain High School from the waterfront site that it's on in Balmain to Wentworth Park, and then they can sell off the Balmain waterfront. So that's probably the property development reason underlying the greyhound racing ban. How did we get onto greyhound racing?
Country bumpkins or not?
I didn't say country bumpkins.
We all heard about ecocide. If people who are actually trying to protect the planet are going to be thrown in jail and have all these draconian things, even if you look like you're thinking about it, what can we do?
Well, one has to be realistic in the way in which one frames solutions. I think to not recognise that the social and economic requirements of human beings have an impact on the planet which may be adverse, but nonetheless, from my point of view, at least as a human rights advocate, human rights come first, and the idea of criminalising any adverse impact on the planet doesn't seem to me to be one which would stand up to scrutiny. But that's not to say that there should be no environmental regulation. And of course there is environmental regulation. The problem always is, and this is the lawyer's answer, is where do you draw the line? And should we move the line further in that direction compared to that direction? And I think there's plenty of good arguments to say that there should be more effective environmental protection, and that indeed is in the ultimate interests of human beings. But I don't think one can be absolutist about it.
We're not calling ourselves protesters, we're calling ourselves protectors. We're protecting.
I think,
so is there a loophole, and is us coming together in community here what you're talking about, coming together to make the change?
Well, the discussion like this is part of coming together. Everybody will express their views in their own way. I would be cautious about language which is absolutist. And part of it's partly inherent in the nature of what a lawyer does, that you're just cautious about absolutist statements. Even in the field of human rights, there are very few human rights that are absolute. Obviously the right to life, well, it's even the right to life, not absolute. There are very few rights, human rights, which can't be derogated from. The true challenge with human rights is striking the correct balance between competing rights and interests. And the human rights approach, the benefit of the human rights approach, which Australia ignores and rejects, is that it provides a well-reasoned, internationally accepted set of standards by which you can assess whether laws and rules are good or not good. You can assess whether laws which restrict the right to protest infringe international standards on free speech by reference to the human free speech right in the International Covenant. And you have the advantage when you do that of looking at all of the countries which have signed up to the international treaty and the way in which they have grappled with exactly the same issue. You don't have to invent the arguments afresh here every time. Or you wouldn't have to if we had a human rights-based legal system. And perhaps I'll finish on this point, because I think this is another way into the argument against the state government. Because I think if you tackle them directly, saying just repeal the laws that you passed in March, they were a bad idea, you're not going to get very far. You've got to find some other strategies to work around. And I think one of the strategies would be to say what we need in New South Wales is better recognition of human rights, like they have in Victoria, like they have in the ACT, where you have a human rights charter which requires Parliament to go through due process when considering new laws, to report fairly on whether or not they're consistent with human rights standards, and then to have government agencies, including the police, have human rights as a value which they're required to uphold. And ultimately, if executive action infringes human rights, the courts can do something to correct the situation. That's the legal system we should have in New South Wales. We don't have it, and we need a movement here to push for it. And with that, I think that might be a good place for me to finish. So thank you very much for inviting me up here.
I guess what cropped up in my mind as Stephen was talking was that laws of this sort of draconian sort always emerge in a certain political context. And the political context in New South Wales is that this shire stood up to the power of corporations and turned those corporations back through collective protest. And that, I think, is one of the main reasons why these laws have been enacted. Why on earth would you reverse the penalties for corporations and protesters if it's not to actually to reverse the power of protesters in relation to corporations? So good on this shire for enabling that protest to actually occur and to be so successful in places like Bentley and so forth. Look, I've just got off the plane from America, and Jen and I have been in America and Canada for the last 6 weeks. Two things struck me most vividly. The first thing that everybody I talked to, and I talked to a lot of Trump supporters actually, and I also talked to Clinton and Sanders supporters, and what actually unites them are two things. One is that everybody talks constantly about the divides in terms of wealth and income in America and Canada, and those divides are chronic. We have in the United States something like 46 million people on or below the poverty line. 22 million of those are in what's called deep poverty. These are people suffering malnutrition, homelessness and the rest of it. We have similar proportions in Canada, and if you go to Vancouver, you'll see thousands and thousands of destitute people roaming around the city centre. Those divides are acute, and I think what we're actually seeing increasingly in Australia and in most Western societies is the backlash of corporations, because they want to hang on to the status quo. The status quo are these enormous divides of wealth and income, and they want to hang on to them. One of the ways they're hanging on to them is to criminalise protests, to criminalise whistleblowers. We know under the Obama regime that more whistleblowers have been criminalised under the Obama regime than any other presidency. We see in Australia the same sorts of things happening this morning. I read in the Sydney Morning Herald about Doctors for Refugees who are on the cusp of protesting laws introduced by this government to criminalise doctors, social workers, nurses and others from speaking out about the despicable things which are going on in detention centres that Stephen talked about. I want to commend Stephen, partly for dealing so effectively with such pressing questions, but also for the Council for Civil Liberties for doing such a fantastic job in fighting this legislation. As Stephen actually said, the laws were enacted without any sense of proper consultation. They are specifically designed to prop up the power of corporations, not only in New South Wales, but throughout the country and beyond. So I think we need to give Stephen and his colleagues another round of applause. The next event, which is in a month's time, we have a person who I think many of you will know personally and otherwise, Professor Stuart Hill. Now, Professor Stuart Hill used to run one of the best courses in Australia before it got unceremoniously gutted by the University of Western Sydney. This was a social ecology course, and I think we've probably got people in here who did that course. Is that right? Anybody in here did the social ecology degree? 1, 2. People who've done that course, you want to talk to them. It was a life-changing course, groundbreaking, one of the best courses to be run in Australia. And as actually happens in today's neoliberal university environment, these fantastic, groundbreaking, threatening courses quickly done away or submerged into other programs. But the legacy of them, the spirit of them, lives on through the graduates. So Stuart's coming to talk here about I think a dozen or so ways in which we can practically protest against neoliberalism. So thank you for being here, and see you next time. Thank you.